The first memo I want to reference is the I-751 memo from 2009. When there's a divorce that happens, I-751 filed prior to termination of marriage. And so we have these situations sometimes where someone gets a conditional green card and the relationship starts to fall apart. And by the time of I-751 filing, the distressful part will be they're separated, but they're not divorced yet. And USCIS is taking the position that they can't approve the I-751 until the divorce is finalized. So it gets pretty tricky. And that's why when people contact us and they're like, my relationship's not too good with my spouse, but I might be able to hang in there. I'm like, don't do that because I-751s could take 2, 3, 4 years to be approved. And that time you're inevitably going to get a divorce. And if you stay in a bad relationship, by the time the interview happens, a bad spouse might be like, I'm not going to go to the interview. And then you're really out of luck with creating problems. And also getting the divorce done as soon as possible is probably better because the states like in California, it could take 6 months for at least for a divorce to be finalized. Now, I haven't done this, but some lawyers have said you could stipulate that the divorce happens sooner, but then like at 6 month mark where it's required, that's when you could discuss possession of goods and property, that kind of stuff in custody. But it varies and depends on state and family law. So I don't want to get into that here. But that's the case. What we do most of the time is the person comes to us, say, okay, immediately file the divorce, and we'll file the I-751 either jointly with the spouse if they're there or separately and have a memo in there that says they're going to update the record of the divorce certificate. And 10 out of 10 times when the clients file pro se divorces, they have errors which take longer to get. So hopefully they hire a divorce attorney. But it really comes in here, like on the bottom, I think it was page 2 of it. If a service center ISO encounters an I-751 petition jointly filed by co-petitioners who are still married but are legally separated and or are in pending divorce annulment proceedings, the ISO issues a conditional permanent resident a request for evidence with an 87-day response period. That's why you want to get that in because if divorce takes longer, you're going to miss that period. But what we've done in the past when they haven't had a divorce in time, we let them know with the divorce filing that we need more time to either issue another RFE or ask for an in-person interview. We'll have the divorce record ready by then. Here it says in the RFE, the ISO specifically asked the CPR, conditional permanent resident, to provide a copy of the final divorce decree or annulment, along with the request stating that he or she would like to have a joint filing petition treated as a waiver. And that becomes really important right there is people sometimes, attorneys sometimes submit a new I-751, something with fee to change it from a jointly filed I-751 to a waiver-based one. But you don't need to do that. Essentially, you just need to make a request to have it changed from a joint filing petition to be treated as a waiver petition, and that's in this memo. This affords the CPR an opportunity to provide evidence that the proceedings have been finalized, and it affords the CPR an opportunity to request a waiver of the joint filing without refiling. So it specifically says you don't need refiling in these kind of situations. You don't want to get caught up in that. If the CPR provides evidence that the proceedings have been finalized, the ISO amends the I-751 indicate that CPR is eligible for a waiver, yada, yada, yada. And then based on the either approve it or schedule an interview. In doing so, the ISO determines whether sufficient evidence, yada, yada, yada. They might even do an in-person interview with them. Now, we've had it where we notified the government of this, that they're getting divorced, and it's not even finalized, and they've approved the I-751, which is annoying because like, you don't have the final divorce certificate. Is that going to be a problem as citizenship? So in those kind of cases, we've mailed the divorce certificate saying, listen, we got the I-751 approved. Feel free to reopen it, but here's the divorce certificate. We want to be on record, so there's no problems. In those cases we had, there's 2 of them in particular we've had that the citizenship case was approved too, but we have it all on the record, so it doesn't look like we're trying to hide something or it's problematic. Or we had it where people file for divorce and we're going to update the government, but a week later, the I-751 was approved. So we immediately contact the government and say, listen, we initiated divorce proceedings, divorce is happening, just so you know that we weren't trying to hide this. So just the timing happened like the way it did. So if you want to reopen it. They did it, and we've had citizenship approved. But these are the kind of like timeline things. And this I-751 waiver, when there's relationships aren't going well, it's probably the worst time part of the immigration process. It gets so tricky unnecessarily. Just I-751 in general is such an unnecessary process. The ombudsman's office did a report back when, like 2 years ago, and they realized like the amount of fraud that happens that it gets caught in the I-751 is so minuscule that it makes the whole process really not worth it. But it's a politically charged one that if you say you're taking away, that's going to rile up a lot of people. But that's there's more info right there. You should definitely read it. Read it. It's not the best written memo, so it's only 3 pages, but you got to read it frequently and a couple times to really get it.